Good evening, one and all. On behalf of Beyond Law CLC and Recruitment Associates, we welcome you all in our endeavor to legal empowerment through resource persons who can actually give us better light on the aspects of law and beyond that. Section 319 CRPC has always illuminated the mindsets and also triggered off a lot of issues. But somewhat after this larger bench judgment on Sukhpal Singh Khaira versus State of Punjab, there have certain guidelines which have been laid down for the purposes of Section 319 CRPC, which they say that to understand any aspect, it is always better to understand through an audio video mode rather than reading it. I don't say that you have to dispense with the reading. It has its own facets to understand the aspects. And once you have a speaker like Murthy D Naik, who is a senior advocate from Karnataka High Court, that right path, right guidelines, I believe that after this session will help the viewers to understand these aspects in a much illuminated manner. Before we request Mr. Murthy to share his insights, I will request Trivikram to say a few words, because Mr. Murthy is from his place, but though they say that all divisions are only in the mindsets, the walls are only in the mindsets, it's only the questions, especially after the COVID. Over to you, Trivikram.
Good evening, Vikas Chetrat sir, and good evening, Murthy sir. Mr. Vikas Chetrat has said it all. I am really running short of words to say anything about Murthy sir. Several reasons. But I can only say that we are going to have a very enlightening session in which we are just anticipating. So with this, sir, once again, on my personal behalf and on behalf of Beyond Law CLC, I extend a very warm welcome to you, sir. Over to you.
Thank you. Thank you, Vikas ji. Thank you, Vikram. In fact, it's quite some time I had not spoken on the platform of Beyond Law CLC. I think last I spoke in November on the topic sameness of FIR. In fact, Vikas ji has been requesting me for various reasons. I couldn't make it. Anyway, thank you once again. And I must also congratulate Vikas and Beyond Law CLC, who have continued on day-to-day basis this webinar series, and it is very useful to all of us. Now, coming to the topic straight away of today's discussion, that is 319 CRPC, and more particularly the focus being on the judgment of the Constitution Bench of the Supreme Court in Sukhpal Singh Khaira versus State of Punjab, which is reported as 2023 1 SCC 289. Friends, before I deal with the said judgment, we will have to briefly refer to the provision that is Section 319 CRPC. As you all are aware, 319 deals with summoning of an accused as an additional accused if during the course of trial or inquiry there is some evidence which is brought before the court, and in such circumstances the court is empowered to summon a particular person as an additional accused. He would be summoned and asked to appear and face the charge. So broadly, 3191 deals with summoning of an additional accused. The word employed there, or rather the impetus, is on the word evidence. If you would closely read 3191 of CRPC, it says it appears from the evidence that any person not being the accused has committed any offense for which such person could be tried together. And then, of course, 319(2)(3) and all speaks about the modalities of summoning, and if he is before the court, then he can be remanded to custody. If he is not before the court, then he would be summoned, etc. All those modalities. Now, this word evidence fell for consideration before another constitution bench of the Supreme Court in Hardeep Singh, which is reported as 2014, volume 3 SEC, page 92. It would be relevant to broadly deal with the law laid down by the Supreme Court in Hardeep Singh's case, because the present case, the present judgment in Sukhpal Singh Khaira has a close relation to the judgment of Hardeep Singh. Now, in Hardeep Singh, the Honorable Supreme Court was considering the vital point as to at what stage can a particular person be summoned as an accused. Because the focus was on the word evidence, meaning thereby evidence that is elicited by a witness during course of an inquiry or trial. Hence, exhaustively it was dealt with, and the Supreme Court ruled that for the till the evidence is recorded, that is evidence on oath, and it can always summon an additional accused immediately after filing of the charge sheet or the complaint. More particularly when an investigation is conducted by a police and a final report is filed in terms of section 173 Cr.PC, then the learned magistrate would proceed to take cognizance under section 190 after applying his judicial mind. Then itself, the concerned court has jurisdiction to invoke 319 is what is held in Hardeep Singh. And various other aspects have been considered. In fact, the points formulated in Hardeep Singh would read thus. For the benefit of the viewers, I would quickly read. In fact, in paragraph 117 of the SEC report, it is reported thus: what is the stage at which power under section 319 Cr.PC can be exercised, and whether the word evidence used in section 3191 Cr.PC has been used in a comprehensive sense and includes the evidence collected during investigation, or the word evidence is limited to the evidence recorded during trial. So this was answered, and it was held that section 319 Cr.PC significantly uses two expressions that have to be taken note of. That is, one, inquiry, to trial. As a trial commences after framing of charge, an inquiry can only be a pre-trial inquiry. Inquiry under section 200 201, 202 Cr.PC, and the chiefs of inquiry templated by three coming for the
Murthy ji, the voice is cracking.
And also to add an accused whose name has been shown in the charge sheet. Sorry.
I was saying some voice is cracking. Just check out the neck part. You can ask your associate to check meanwhile.
Yes.
The signal is slightly weak.
Okay, I think now it is better. Now it is okay, Vikasji?
Now it's better.
Yeah.
Let's see. I'll ask people to put it in the chat in case there's any problem.
Yes, you can also tell me.
Yeah.
So these were broadly the questions formulated in Hardeep Singh, and it was answered to the effect that you need not wait till the evidence is recorded on oath. And accordingly, it was disposed of. And the important feature of Hardeep Singh's judgment is the Supreme Court dealt with the aspect of or issue of as to when a trial commences. It was held that trial commences once the charge is free and not before that, and prior to or anterior to the framing of charge, all the stage would come within the realm of inquiry. So this was held by the Constitution Bench. But however, in one of the cases subsequent to Hardeep Singh, and Hardeep Singh holds the field as far as this issue is concerned. However, various safeguards have been mentioned therein, and the earlier proposition to the effect that one should not mechanically summon a person who is not either named in the FIR or not named in the charge sheet altogether. One should be slow and circumspect in summoning such a person, because he will be relegated to the rank of an accused. Hence, one should be very careful, and unless there is sufficient material to indict a particular person and summon him to face a charge, then one should not summon such a person, is what has been held in Hardeep. Subsequently, in one of the cases, the Honorable Supreme Court had the occasion to examine a judgment of the year 2002, that is Shashikant Singh versus Tarkeshwar Singh, wherein it was held that a person can be summoned even after completion of trial. Hence, to throw some light or to get more clarity on the point as to when a trial culminates, or to put it differently, when does a criminal trial come to an end, and can a person be summoned after the completion of trial. Hence, in this backdrop, the present judgment, which is the topic of discussion, that is Sukhpal Singh Khaira versus State of Punjab, came to be decided. The brief facts, it would be necessary to dwell and refer to the facts of this case. Here, the petitioner was summoned in an FIR which was registered by one of the police station in Punjab for various offences under the NDPS, IT Act, Arms Act, etc. The charge sheet was filed against 10 accused persons originally, and a second charge sheet, that is an additional charge sheet, was filed. There also the present appellant was not named. Hence, one thing in both the charge sheets, the present appellant, that is Sukhpal Singh Khaira, was not named as an accused. Then the trial commenced in respect of these 10 accused, or rather 11 accused, and ultimately the trial proceeded. And after initial recording of the evidence, the prosecution filed an application under 311 for recalling 2 witnesses, which came to be allowed, and their evidence was recorded. During the course of recording of their evidence, the said witnesses spoke about the present appellant, and hence, on that basis, the prosecution filed an application under 319 Cr.PC saying, look here, there is material against the present appellant. And also, the application was not only filed against the present appellant, but it was filed against 5 accused, additional 5 accused, saying that you exercise your power under 319, summon them. They sought summoning on the basis of evidence of those 2 witnesses and another witness, that is PW1. That is what is borne out from the judgment of the Supreme Court. So on the basis of these evidence of these 3 witnesses, the prosecution sought summoning of the 5 accused. It is also important to note that out of the 11 charge sheeted accused, 1 was absconding. Hence, the trial was going on in respect of only 10 accused. As far as 1 accused is concerned, the trial was split up, or rather the case was split up, it was bifurcated and was subsequently renumbered. A separate number was assigned to the other case in respect of the absconding accused. And in that background, when the application was filed under 319, what was pending was the main case, that is as far as 10 accused persons. So the learned sessions judge, after completion of the trial in respect of these 10 accused persons, acquitted 1 accused and convicted the remaining 9 accused, and the order of sentence was also passed on the same day. That is, judgment of conviction, holding the 9 accused guilty and acquitting 1 accused, as well as sentencing them, was done on the same day. Because this is very crucial, because it revolves around the sentencing part, which I would deal with a little later. On the very same day, that is on the day when the judgment was passed and the order of sentence was also pronounced, the learned sessions judge allowed the application filed by the prosecution under section 319 and summoned the appellant to face trial. So it was in this background the appellant assailed the said order by filing a revision petition before the High Court, and the High Court was pleased to dismiss the revision. Hence, the appellant approached the Supreme Court, and hence the Supreme Court was dealing with the issue, which ultimately came to be referred to the Constitution Bench of 5 judges. What prompted the 2-judge bench to refer this to the Constitution bench was the decisions of the court, which I referred to earlier, that is Shashikant Singh versus Tarkeshwar Singh, which is reported as 2002, volume 5 SEC 738, and the decision of Hardeep Singh. So in that, as I told you all earlier, in Hardeep Singh, the Supreme Court had only dealt with and authoritatively held that the trial commences once the charges are framed. So the actual stage at which the trial is said to have been concluded was nowhere dealt with in Hardeep Singh's case. Hence, that prompted the learned judges of the Supreme Court, 2 judges of the Supreme Court, to refer the matter to Constitution bench. And the 3 points were formulated. Broadly, the first point, which was referred, which was formulated and point of reference, was whether the trial court has the power under section 319 Cr.PC for summoning additional accused when the trial with respect to other co-accused has ended and the judgment of conviction rendered on the same date before pronouncing the summoning order. 2, whether the trial court has the power under section 319 Cr.PC for summoning additional accused when the trial in respect of certain other absconding accused is ongoing or pending, having been bifurcated from the main trial. 3, what are the guidelines that the competent court must follow while exercising power under section 319 Cr.PC. So these were the 3 points for consideration that were formulated, and ultimately it was referred to the Constitution. The Constitution bench heard this matter for a good number of days, and after hearing all the learned counsels appearing on both sides, and also hearing the amicus who was appointed to assist the court, came to a conclusion, and ultimately an authoritative pronouncement has been passed. Now, before I deal with the actual decision of the court, it would be necessary to broadly touch upon the submissions put forth by the learned counsels, more particularly the learned senior advocate for the appellant, because the appellant was assailing an order of the Sessions Court by which he was summoned under 319 on the date when the sentence was pronounced, which was confirmed, in essence confirmed by the High Court of Punjab. Hence, he was before the Supreme Court. So broadly, the contentions put forth by the appellant's counsel was that 319 in this case was invoked when the trial had already concluded and even the judgment and order of conviction and sentence had been pronounced, and hence nothing was pending with the trial court, and hence it could not have exercised the power under section 319 Cr.PC, because 319 mandates that the power should be exercised only during trial, and hence once the trial had concluded, the Sessions Court did not have any jurisdiction to exercise power under section 319, was the main limb of the argument put forth by main limb of the argument put forth by the learned counsel for the appellate. And also it was argued that it was in violation of section 319 CRPC, and more particularly paragraph 47 of Hardeep Singh's judgment. That is the reason I broadly referred to the judgment of Hardeep Singh, because it has a direct bearing on this case. So para 47 was pressed into service, and it was argued that the power under section 319 has to be exercised before pronouncement of judgment. So this was the main submission that was put forth. And additionally, it was also contended that the accused is to be summoned only when a trial is alive. So a fine distinction between a live trial and a trial which has concluded after pronouncement of judgment. And in this case, it was judgment of conviction, and also the sentence had been passed. So it was argued that once that exercise was undertaken, the learned sessions judge had become functus officio, hence he could not do it. Likewise, the learned amicus curiae was also of the same opinion, but however, he had his own reasonings. And broadly, if I have to touch upon the gist of the contentions urged by the learned amicus, it was contended that before taking cognizance under section 190 CRPC and after pronouncement of judgment, the court has no power under section 319 CRPC, and in view of Hardeep Singh, the trial court does not have the power for summoning additional accused when trial with respect to other accused has ended and judgment of conviction has been rendered on the same date. Likewise, the learned Advocate General for the state of Punjab, learned Additional Solicitor General, all were heard, as I told you all earlier. But the hearing in this case was, in fact, it was live streamed and it went on for a good number of days. The state, naturally, it had to support the order of the learned sessions judge. So it was contended on behalf of the state government that 319 was introduced by the legislature with the sole intention or with the sole object that no culprit should go scot-free, and in order to bring home the guilt of actual accused, this provision was introduced in the CRPC. Hence, one cannot dilute the intention of the lawmakers, and hence it supported the order passed by the High Court. Likewise, the various other additional advocates general of various states were heard, and even the learned additional solicitor general was heard. And finally, the Supreme Court has in paragraph, now if you would take the SCC judgment, it has referred to in paragraph 14, it has referred to the section in its entirety, and then has also referred to the 41st report of the Law Commission, just to examine the intent or the intention behind the introduction of Section 319 CRPC. So all those reports have been, the relevant portion of the report pertaining to 319 has been culled out. And also the relevant paragraphs from Hardeep Singh's judgment has been culled out. And it also referred to Shashikant Singh's judgment. In para 18 of the SEC report, you would find the reference to Shashikant Singh's judgment. See, in Shashikant Singh, it would be necessary to briefly mention the facts of Shashikant Singh's judgment. There, his brother, that is one Shivkant Singh, was murdered, and trial proceeded against one Chandrasekhar Singh. When the evidence was recorded, it was found that Tarkeshwar Singh and two others had also committed or participated in the offence of Shivkant Singh. Hence, the learned additional sessions judge exercised power under 319 in order to issue a warrant of arrest so that they may be tried together with Chandrasekhar Singh, the accused who was already facing trial. The said summoning order came to be assailed before the High Court by way of a criminal revision petition. And it was pending for some time. And during the pendency of the said criminal revision petition, the trial against the main accused, that is Chandrasekhar Singh, came to be disposed of. And he was convicted by judgment dated 16/7/2001. So the question which arose in the case, in that context, was, in the case of Shashikant Singh, was whether the trial in the case in which additional accused were summoned under Section 319 CRPC, including Tarkeshwar Singh, can proceed in view of the phrase "could be tried together with the accused" contained in Section 319, subsection 1 of CRPC, because the trial against the other accused had concluded with the order of conviction. The Honorable Supreme Court held that the trial can commence as against these two accused by virtue of the summoning order. So in this backdrop, the Honorable Supreme Court, the two judges bench, thought it fit to refer it to the Constitution bench. And as I referred to the 3 points for consideration, they were the points of reference which were referred. So on that basis, the Honorable Supreme Court dealt with entire aspect revolving around 319 CRPC, commencing with 232, that is acquittal, 235 judgment of acquittal or conviction, and copiously dealt with Chapter 27 of CRPC, wherein sections 253 and 254 are placed. 353 and 354 are placed. As you all know, 353 of CRPC deals with judgment, and 354 deals with language and contents of judgment. Hence, these provisions were copiously considered. And then in para 27 of the SEC report, there is an observation to the effect that the in essence, the Supreme Court has held that the trial can continue. Exhaustive guidelines have been laid down, and before that, reference has been made to the earlier judgments of the Supreme Court, wherein 3 honorable judges had decided Ram Narang versus Ramesh Narang, that is 1995 to SEC 513, and Yaqub Abdul Razak Memon versus State of Maharashtra, that is the Bombay bomb blast case, that is the first Bombay bomb blast case, 2013, 13 SEC page 1. And has laid down the guidelines. So, first, it has answered the questions that were referred, and you would get it at paragraph 38. In paragraph 39, the Supreme Court has bifurcated the answers, which I would deal with one by one. Firstly, for the benefit of the audience, I would once again read the first point of reference. That was whether the trial court has the power under section 319 Cr.PC for summoning additional accused when the trial with respect to other co-accused has ended and the judgment of conviction rendered on the same date before pronouncing the summoning order. So the Supreme Court has held that the power under section 319 is to be invoked and exercised before the pronouncement of the order of sentence where there is a judgment of conviction of the accused. And then it has held that in case of acquittal, the power should be exercised before the order of acquittal is pronounced. Hence, it has bifurcated. That is, if the accused who has already faced trial is convicted, then the power under 319 is to be exercised if provided there is an application pending, or if the court suo motu finds that there is evidence against additional accused or other persons who are to be summoned as additional accused by invoking the provisions of 319 Cr.PC. Then it has to be done before the sentence is pronounced, as far as the accused who have faced trial. If now the second scenario would be if the accused are acquitted. Accused, or if he or she is a sole accused, or if there are number of accused, if he or she is acquitted, then before the judgment of acquittal is pronounced, power under 319 has to be invoked, and further it has been held that summoning order has to precede the conclusion of trial by imposition of sentence in the case of conviction. So, in essence, the Supreme Court has held that the trial will conclude the moment the sentence is pronounced, because there was certain discussion that once a case is posted for judgment, then the trial comes to an end, and hence 319 cannot be. This is what was sought to be argued. Hence, the Supreme Court has clarified that the trial will come to an end after imposition of sentence. Hence, it says that the summoning order should precede the conclusion of trial by imposition of sentence in case of conviction. And it also says that if the order is passed on the same day, it will have to be examined on the facts and circumstances of each case. And if such summoning order is passed either after the order of acquittal or imposing sentence in the case of conviction, the same will not be sustainable. So, sine qua non is, or to put it differently, the outer limit or the outer period by which the court can exercise its power under 319 is one in case of a conviction before the sentence is pronounced, in case of an acquittal before the judgment of acquittal is pronounced. If anything done after these two contingencies, it is unsustainable in the eye of law. Now, coming to the second point for consideration that was formulated, that is whether the trial court has the power under section 319 Cr.PC for summoning additional accused when the trial in respect of certain other absconding accused whose presence is subsequently secured is ongoing or pending, having been bifurcated from the main trial. To simplify the question that is formulated for the benefit of the viewers, the said point was with regard to the trial of an absconding accused. So, in essence, the question deals with whether 319 can be for summoning additional accused when the trial in respect of the absconding accused whose case was originally split up from the other accused who were facing trial and whose presence was subsequently secured is pending and going on, but is bifurcated from the main trial. So here the Supreme Court has answered this question to the effect that the trial court has the power to summon additional accused when the trial is proceeded in respect of the absconding accused after securing his presence, subject to the evidence recorded in the split up bifurcated trial pointing to the involvement of the accused sought to be summoned. But the evidence recorded in the main concluded trial cannot be the basis of the summoning order if such power has not been exercised in the main trial till its conclusion. So it is very simple. Like in this case, there were totally 11 accused, of which one accused was shown as absconding. Hence, the trial against him was split up or bifurcated. Trial against 10 accused commenced. and it reached the stage of judgment. So in such case, if the court doesn't invoke power under 319, and if that case either ends in conviction or acquittal, as the case may be, then nothing can be done. But in the split up trial, that is a trial in respect of the split up accused, is going on, and certain evidence surfaces as against an additional accused. Then, on the basis of the said evidence that was led in the subsequent trial, can be made basis for summoning an accused. But the court cannot bank on the original evidence, even if there are some material against the proposed accused. Once the judgment is pronounced and order of conviction or acquittal is pronounced, and in case of order of conviction, sentence is also pronounced, then the evidence of the first case cannot be made a basis, even if there are some materials against the proposed accused. In the split up case, having said that, the basis would be the evidence that has been led in the split up case. It can't be combination of evidence of the first trial and combination of evidence in the second trial. This is what has been held, and accordingly, point number 2 has been answered. Now, point number 3 pertains to the various guidelines. In fact, exhaustive guidelines have been laid down, which commence at paragraph 41.1 of the SEC report, and they extend up to paragraph 41.12, meaning thereby 12 guidelines have been laid down by the Supreme Court. Now we will refer to each of the guidelines individually. Firstly, it has been held that if the competent court finds evidence, or if application under section 319 Cr.PC is filed regarding involvement of any other person in committing the offense based on evidence recorded at any stage in the trial, before passing of the order on acquittal or sentence, it shall pause the trial at that stage. Which means that if it is before passing an order of acquittal or sentence, that is much before that stage, then it can stall the trial, is what has been held. That is guideline number 1. Guideline number 2 is the court shall thereupon first decide the need or otherwise to summon the additional accused and pass orders thereon. Which means once you stall the proceedings, that is the further trial at a particular stage, if a decision is taken or if an application is filed under 319, then you will have to first decide on the need to summon the additional accused. Then guideline number 3, if the decision of the court is to exercise the power under section 319 Cr.PC and summon the accused, such summoning order shall be passed before proceeding further with the trial in the main case. So before the court wants to proceed further with the main case, it has to pass the summoning order, because the first guideline says that you have to halt the trial. Second says you have to first decide whether there is a need. Third says you have to, if you come to a conclusion that there is a necessity to summon a particular accused by invoking 319, then before proceeding with the further trial, you will have to pass the summoning order. Now, fourth guideline is if the summoning order of additional accused is passed, depending on the stage at which it is passed, the court shall apply its mind to the fact as to whether such summoned accused is to be tried along with the other accused or separately. So the court has to decide whether they have to be tried along with the accused in respect of whom the trial has already commenced and it has proceeded. Or else it has to be the summoned accused has to be tried separately. Then guideline 5, if the decision is for joint trial, fresh trial be commenced only after securing the presence of summoned accused. Meaning thereby, if de novo trial will have to be conducted if the court invoking powers under 319 comes to the conclusion that it would be conducive to hold a joint trial, then a fresh trial will have to be ordered by, or rather after securing the presence of the summoned accused. Guideline number 6 is if the decision is that the summoned accused can be tried separately on such order being made, there will be no impediment for the court to continue and conclude the trial against the accused who were being proceeded with. If the court decides that the trial can be conducted independently and there is no need for a joint trial, then the trial can commence. The trial which was halted can proceed further. Guideline number 7, if the proceeding paused as in para 41.1 above is in a case where the accused who had tried are to be acquitted and the decision is that the summoned accused can be tried afresh separately, there will be no impediment to pass the judgment of acquittal in the main case. It is very clear that the trial that was paused as held in guideline number 1, which was halted for the purpose of deciding the application under 319 or deciding the necessity for summoning, continues, and the accused who were tried are to be acquitted. The decision is that the summoned accused can be tried afresh separately. There will be no impediment for the court to pass a judgment of acquittal. Guideline number 8 is if the power is not invoked or exercised in the main trial till its conclusion, and if there is a split up, bifurcated case, the power under section 319 Cr.PC can be invoked or exercised only if there is evidence to that effect pointing to the involvement of additional accused to be summoned in the split up bifurcated trial. As I stated earlier, the basis for summoning the additional accused would be the evidence that is led in the split up case and the evidence that has been recorded in the main trial cannot be the basis. This is the essence of this guideline number 8. Now, guideline number 9 is if after arguments are heard and the case is reserved for judgment, the occasion arises for the court to invoke and exercise the power under section 319 CRPC, the appropriate course for the court is to set it down for rehearing. Guideline number 10, on setting it down for rehearing, the above laid down procedure to decide about summoning, holding a joint trial or otherwise shall be decided and proceeded with accordingly. Guideline 11, even in such a case, at that stage, if the decision is to summon additional accused and hold a joint trial, the trial shall be conducted afresh and de novo proceedings be held. And finally, guideline number 12, if in that circumstance, the decision is to hold a separate trial in case of summoned accused, as indicated earlier, then two aspects are laid down. A, the main case may be decided by pronouncing the conviction and sentence and then proceed afresh against summoned accused. B, in case of acquittal, the order shall be passed to that effect in the main case and then proceed afresh against the summoned accused. Hence, friends, these are the 12 guidelines. Additionally, the 2 points for determination were also answered. And I think with this judgment, it is clarified and the cloud that was subsisting with regard to the aspect or regard to the question as to when does a trial conclude has been laid to rest. Now I hope with this judgment, that is Sukhpal Singh Khaira, if read in conjunction with Hardeep Singh, the law with regard to section 319 CRPC is well defined. I don't think there is any scope for ambiguity henceforth. And this being a constitution bench judgment, which has been delivered after hearing exhaustive arguments and after considering all the long line of decisions on the said point and also on the other aspects of criminal trial, will hold the field for a good number of years, because according to me, there is no scope for reconsideration or tinkering with any of the aspects. So I think this would be of great help in deciding applications under section 319 at any stage. Thank you.
Thank you, sir. Thank you very much for enlightening us.
Yes, in fact, I think I have overstepped by around 10 minutes.
That's okay. That's okay, sir. That's the reason I think we have very few questions with regard to the judgment.
Yes.
But apparently we have something related to section 319. I think we'll take up one post by Mr. Manoj Kamra. Sir,
Yes.
please suggest remedy in case of refusal by magistrate to admit 319 CRPC despite specific evidence in the arguments.
You can file a revision petition or a petition under 482.
So he can invoke 397 before the sessions court or 482 before the honorable.
Yes, if it is an application filed before a learned magistrate, that is in a trial which is being conducted by a magistrate, then a revision can be filed to the sessions court. Or if it is a case pending before the sessions court, then you can file a revision to the High Court under 397 read with 401. or you can file a 482 petition under 482, because a revision petition would be maintainable, because this would not be an interlocutory order.
Yes, sir.
This would in fact be a final order of rejection to summon a particular person would be a final order, because it determines right of a person, and that is one of the tests. Hence, a revision or a 482 application can be filed.
Both are maintained.
Yes.
Srihari has a question, sir. In the new judgment, has the court deviated or held contrary to Hardeep Singh's case on any point?
No, nothing. See, that's the reason I dealt with and broadly touched upon Hardeep Singh. Hardeep Singh, the points for consideration were totally different. It had the emphasis was on the word evidence. At what stage can a 319 order be passed? In fact, that was one end of the spectrum. So there it was held that even immediately after taking cognizance, you can invoke section 319 and you don't have to wait till the formal evidence is recorded. So that is the first stage, that is immediately after cognizance, you will summon the accused. So while examining the papers, that is the stage of inquiry. If it is upon a police report, while you are examining the papers for the purpose of taking cognizance under section 190, if the court finds that certain other accused have been left out from the charge sheet, then 319 can be invoked, is what has been held in Hardeep Singh, saying that you don't have to wait till the formal evidence, and evidence includes the materials collected by the prosecution during the course of investigation and submitted along with the final report under section 173(2). So that is one end of the spectrum in Hardeep Singh. So it had also held that trial commences once the charge is framed. Here is other end of the spectrum. Till what stage can you invoke 319? So it has been held that you can invoke 319 up to the before the sentence is pronounced or the order of acquittal is pronounced. So these are two. So there is no conflicting views in both of them. Both will throw light on individual aspects. They are not overlapping. The points for considerations are not overlapping. Hence, it would be ideal that the viewers refer to both the judgments and minutely examine, because there is no scope for any ambiguity or confusion.
Right, absolutely. I think that's all from my end, Mr. Vikas.
One question is whether session and the High Court has a concurrent jurisdiction with reference to filing of the criminal revision against 319.
Yes, see, not only 319, it has concurrent jurisdiction. The very reading of the provision 397, 401, and it has been held by the Supreme Court also, that you can either approach the Sessions Court by way of revision or High Court. Only thing is, if you approach the High Court directly, you would be losing one forum, because against an order passed in a revision, though second revision is not maintainable, under 397(3), you can file a 482. So revision is concurrent. Revisional jurisdiction of a Sessions Court and High Court is concurrent, just like 438 and 439.
The last question, can a person placed in the column 12 in the charge sheet can a person placed in a column number 12 in charge sheet file a defamation case, civil/criminal, against a criminal before the conclusion of the trial, and does it have any impact on the application filed under section 319 if filed during the trial?
I think the question is too convoluted. So it is better, and it is besides the point. I don't think there is necessity to answer.
More on presumption.
Yes, and it is very convoluted. One can't understand. So it is better we leave it.
Yeah. So thank you, Trikram, for connecting us with Mr. Murthy Naik. And as usual, his session was quite eloquent, and people will have a lot of takeaways for the session. And tomorrow, friends, we will connect at 6 p.m. on a bird-eye view on the Indian Partnership Act with special focuses on exams on judicial papers as well ADA and company secretary, etc. So do connect us at 6 p.m. Thank you.
Thank you.